Hello, I'm Tom Cattee, a white-collar crime and extradition solicitor at Gherson Solicitors, and today I'm going to speak about how you can find out if you're subject to an INTERPOL Red Notice, and if so, what steps you can take to do something about it. So the first question to ask is, how do I know if I'm subject to an INTERPOL Red Notice? Now, when a member state requests Interpol to publish data on a suspect or convicted person, Interpol will send this data to every member state's database. There's also a publicly available list. However, sometimes the requesting member state will expressly request that the suspect or convicted person's data is not published on the publicly available list. The first step, of course, is to check the publicly available list. However, inquiries could also be made to Interpol to establish whether or not you're on the private list. Although expert advice should always be sought before doing this, as this can potentially reveal your location to the requesting member state. Further, Interpol are not necessarily obliged to disclose whether they hold any data on you. Gherson solicitors have extensive experience in dealing with these types of sensitive requests. I'm now going to briefly outline 4 ways in which one might challenge an Interpol Red Notice. The first way to challenge an Interpol Red Notice is through challenging the validity of the notice. In this regard, the Interpol rules state that the offence must be a serious, ordinary law crime. As such, red notices must not be issued in relation to private or civil disputes. There are also provisions relating to the length of any applicable sentence. Now, Interpol retains some discretion here, so this may be the weakest route of challenge, although of course it always remains a potential route to recourse. The second way to challenge a red notice is through another provision of the rules, which provide that sufficient details must be provided. Given the volume of red notices that Interpol receive, it is often worth ensuring that Interpol have made the relevant details in inquiries in relation to these thresholds. There's often ample scope to make your case through representations to Interpol to explain why the thresholds might not have been met. The third way to challenge the validity of a red notice is if it can be argued that mutual assistance with the requesting member state request is not in the spirit of the Universal Declaration on Human Rights. This could involve, for example, proving that the requested state will not offer the individual a fair trial in relation to Article 6 and Article 10 of this declaration. The fourth route to challenge the validity of a red notice is through Article 3 of Interpol's Constitution. Now, Article 3 details that it is strictly forbidden for Interpol to undertake any intervention or activities of a political, military, religious or racial character. Now, overall, there's no strict best way to challenge an Interpol Red Notice request. Rather, the strategy for challenging the Red Notice must be carefully considered in the context of the request and the specific factual nexus. Gherson solicitors are able to offer expert advice if you have, or fear that you may have, an outstanding Red Notice against you. Gherson solicitors have over 30 years of experience in dealing with all aspects of Interpol and Red Notice challenges. If you would like to speak to us in respect of any of the issues raised in this video or about your specific circumstances, then please do not hesitate to contact us for advice. Send us an email or alternatively follow us on Twitter, Facebook or LinkedIn to stay up to date. Thank you very much for watching this video.